Greetings and welcome to Making Your Case, the Art of Persuading Judges, Part 4. We're going to be going over Part 4 of this presentation, and of course we'll have Black's Law Dictionary, 9th edition, at our side to make sure we leave no word behind. Although the authors have been quite generous in ensuring that we have everything we'll need to comprehend the text that we're about to look at. So let's get right started with it. We left off last time with section 14. Before I go any further, I just want to greet everyone here. Semantic Earth, greetings. And anyone else who's here, please hit the like and just chime in the chat so I make sure I'm broadcasting well to everyone out there. And I just wanted to mention that nothing here tonight is to be used for anything other than the educational entertainment purposes it's intended for, not to be used for any of your professional, personal, lawful, legal uses. Don't do this at home. All right, on that note, let's get started with it. So, section 14 is where we left off. Give me a moment here. Let me get back to, here we go. Always start with a statement of fact of the main issue before fully stating the facts. So, Cicero advised that you must not spring at once into the fact-specific part of your presentation, since it forms no part of the question, and men are at first desirous to learn the very point that is to come under their judgment. In 1981, the rules of the Supreme Court of the United States were amended so that the first thing a reader sees upon opening the cover of a brief is the question presented. Many court rules, however, don't require issues or questions presented to be up front, or even to be set forth at all. That's regrettable, because the facts one reads seem random and meaningless until one knows what they pertain to. Whether you're filing a motion in a trial, or an appellate brief, or for that matter, an in-house memorandum analyzing some point of law, don't ever begin with a statement of facts. State the issue first. The greatest mistake a lawyer can make, either in briefing or oral argument, is to keep the court in the dark as to what the case is about until after a lengthy discussion of dates, testimony of witnesses, legal authorities, and the like. Few judges, after eventually finding out what the case is about, can back up in their mental processes and give proper consideration and evaluation to such narrative matter. And that comes from the Honorable Luke M. McCamus. But while your statement of the issue should come before a full statement of facts, it must contain enough of the facts to make it informative. Whether the appellant was in total breach of contract is little help, but not much. Fill in the facts that narrow the issue to precisely what the court must decide. The appellant delivered a load of stone 2 days late under a contract not providing that time was of the essence. Was the appellee entitled to reject the delivery and terminate the contract? Nice and to the point. Let's read this again. The appellant delivered a load of stone 2 days late under a contract not providing that time was of the essence. Was the appellee entitled to reject the delivery and terminate the contract? Now that gets to the heart of the matter. Excellent. Let's move on to section 15. Appeal not just to the rules, but to justice and common sense. This is an excellent section here, so let's dive deep here. Courts have been known to award judgments that seem to be unjust or to defy common sense. A defective statute or a defective Supreme Court precedent can, in the eyes of most judges at least, require such a result. But don't count on it. Consider the philosophy of Lord Denning, regarded by one of the greatest of the 20th century British judges. Yes, Semantic Earth, that last one was excellent, and I think as we go through this text here, we'll find that this late justice definitely did have some good perspectives. Whether we agreed on his particular points of jurisprudence in the end or not, it's worth really looking into the wisdom of what he conveys here in these pages. So appreciate that, and let's proceed. All right, now we're back to the philosophy of Lord Denning, regarded as many as one of the greatest of 20th century British judges. Last century, right? My root belief is that the proper role of a judge is to do justice between the parties before him. If there is any rule of law that impairs the doing of justice, then it is the province of the judge to do all he legitimately can to avoid that rule, or even to change it, so as to do justice in the instant case before him. He need not wait for the legislature to intervene, because that can never be of any help in the instant case. Now, this is wow. Let's dissect this a bit more here, because as the proper role judge to decide between the parties before him, if there's any rule of law that impairs the doing of justice between the parties before him, it's the province of the judge to do all he legitimately can to avoid that rule. To avoid, which is an important verb here to consider. For a judge to avoid a rule, or even to change it, so as to do justice in the instant case before him, between the parties before him. This is great. He need not wait for the legislature to intervene, because that can never be of any help in the instant case. This is a good term we should know, instant case. To be sure, Denning was a renowned judicial activist, or a notorious one, if that is your view of things. But a similar, if not quite identical, approach was endorsed by the famous Chancellor James Kent of New York. I saw where justice lay, in the moral sense decided the cause half the time, and then I sat down to search the authorities until I had exhausted my books, and I might once in a while be embarrassed by a technical rule, but I almost always found principles suited to my views of the cause. So, let's see, where justice lay, in the moral sense, decided the cause half the time. And then, all right, so that's quite circuitous there, yet it does get to the point here. I most always found principles suited to my views of the case, so it takes diligent research. Now, you may think that the principles contained in the authorities ought to lead a judge to his or her conclusion, rather than merely provide latter support for a conclusion arrived at by application of the judge's moral sense. And you'd be entirely right. We're not giving advice here, however, not to judges, but to the lawyers who appear before them. You can bet your tasseled loafers that some judges, like Lord Denning, will be disposed to change the law to accord with their moral sense, or, as we see in some of the more modern liberal-minded judges, the immoral sense, and that many more will, like Chancellor Kent, base their initial decision on their moral sense, and then scour the law for some authority to support that decision. Oh boy, well that's nice to dream about. but I see few judges really doing that kind of work. It is therefore important to your case to demonstrate, if possible, not only that your client does prevail under applicable law, but also that this result is reasonable. So you must explain why it is what might seem unjust is in fact fair and equitable in this very case, if possible. And if not there, then in the vast majority of cases to which the rule you are urging will apply. You need to give the court a reason you should win that the judge could explain in a sentence or two to a non-lawyer friend. Holy shit, this is good. You need to give the court a reason you should win that the judge could explain in a sentence or two to a non-lawyer friend. Rely fully on the procedural and technical points that support your case. If, for example, a particular constitutional objection was not raised below and was not addressed by the lower court, say so. Whenever possible, however, accompany the procedural or technical objection with an explanation of why the permitted point is in any event wrong, or at least weak, on the merits. Judges will indeed dispose of cases on procedural or technical grounds, but they will do so much more reluctantly if it appears that the claim thereby excluded is a winner. You cannot make a plausible case on the merits, then point out how the procedural or technical bar is necessary to ensure the correct result in the long term. This is critical here too. A real life example. In a recent arbitration in Arkansas, or Arkansas, the discovery cutoff came and went on February 15th, by which time the parties had taken lengthy depositions and made voluminous production of documents. Counsel had 1 month left to prepare for the March 15th arbitration, which was slated to last 2 weeks. On March 8th, the defendants issued subpoenas to 4 witnesses employed by the plaintiffs, requiring them to produce within 5 days all sorts of documents that the defendants had never before requested. The plaintiffs objected on the grounds that the discovery cutoff had passed, but the arbitrators ordered the plaintiffs to produce the documents. The result? During the week before trial, yes, in terms of the work required, an arbitration is essentially a trial. While the defendants' lawyers were readying themselves, preparing their witnesses and assembling the documentary evidence, the plaintiffs' lawyers were scrambling to gather the documents required by the 11th hour subpoenas. The argumentative mistake? In objecting to the subpoenas, the plaintiffs' lawyers argued merely the obvious. 1, the discovery deadline had passed, and 2, the defense could have requested these documents much earlier. The objections seemed hardly to register in the 3 arbiters' minds. Here's what the plaintiffs could have and should have argued. All right, let's get this one. Plaintiffs' counsel should not be forced to stop preparing for trial 1 week away and travel to 4 cities on both coasts to find documents that the defendants never asked for before the expired discovery deadline. There is a reason for discovery deadlines. They level the playing field. If the defendants succeed in this last-minute stratagem, the plaintiff's team will be severely prejudiced. 1 week from the trial date, we should not be forced to conduct a frenetic scramble for newly subpoenaed documents, nor should we be forced, in order to avoid that consequence, to request a deferral of the agreed-upon trial date, further delaying the justice our client is seeking. Although we are sure the defense lawyers mean well, the effect of what they have done is major league sandbagging. We urge the panel to quash the subpoenas. Man, that's good. That might have worked. Certainly, it stood a better chance than merely harping on the deadline. If there is prejudice, never fail to identify and argue it. Ooh, another great point. 16. When you must rely on fairness to modify strict application of the law, identify some jurisprudential maxim that supports you. And of course, if you're subscribed to the channel, you would have watched the 20 episodes we did of maxims of law in English. Let's proceed here. A naked appeal to fairness in the face of seemingly contrary authority isn't likely to succeed. Whenever possible, dress up the appeal with citation of some venerable legal maxim that supports your point. Such maxims are numerous, mostly derived from equity practice. For example, when the reason for a rule ceases, so should the rule itself. One must not change his purpose to the injury of another. He who consents to an act is not wronged by it. So these are maxims like of consent, intent, of rule. Acquiescence in error takes away the right of objecting to it. No one can take advantage of his own wrong. And I think that comes into liability or blame. He who takes the benefit must bear the burden. The law respects form less than substance. Nice, because remember, the law is the rule of right, which would be another maxim. The state of California has codified many of these maxims with case summaries exemplifying their application. Interesting. Courts in other states are no less familiar with such maxims, and you can almost always find one to support a defensible position. Excellent. All right, we're on to section 17. Understand that reason is paramount with judges, and that overt appeal to their emotions is resented. It is often said that a jury argument will not play well to a judge. Indeed, it almost never will. The reason is rooted in the nature of what we typically think of as jury argument, a blatant appeal to sympathy or other emotions, as opposed to a logical application of the law up to the facts. Before judges, such an appeal should be avoided. Some authorities, though not most, defend some degree of appeal to emotions. Every argument must be geared so as to appeal both to the emotion and to the intellect. I think the basic difference between a competent advocate and a great one is that a competent advocate can only do one or the other, or thinks only one or the other is important. You can get competent advocates who are very good in emotional cases because they are adept in appealing to the emotion. You get competent advocates who are successful in cases that are on the dry side because they have the knack of appealing to the intellect. But a great advocate is one who can appeal to both and knows how to press the two appeals in such a way that one will not get in the way of the other. Interesting. We hold strongly to a contrary view. It is both folly and discourtesy to deliver a jury speech to the New York Court of Appeals. It will surely win no votes. You are fortunate if the judges will attribute such misconduct to your ignorance rather than the vulnerability of your case. Jeez. Appealing to judges' emotions is misguided because it fundamentally mistakes their motivation. Good judges pride themselves on the rationality of their rulings and the suppression of their personal proclivities, including, most especially, their emotions. And bad judges want to be regarded as good judges. So, either way, overt appeal to emotion is likely to be regarded as an insult. What does this lawyer think I am? An impressionable juror? That's a good one. When a lawyer resorts to a jury argument on appeal, you can just see the judges sit back and give a big sigh of relief. We understand that you have to say all these things to keep your client happy, but we also understand that you know, and we know, that you know we know, and that your case doesn't amount to a hill of beans. So we can go back there in the conference room and flush it with an unpublished disposition. And that's from the Honorable Alex Kaczynski. Yikes. There is a distinction between appeal to emotion and appeal to the judge's sense of justice, which, as we have said, is essential. That jurisprudence we just spoke about and the maxims is a good way to appeal to their sense of justice. Of course, you should argue that your proposed rule of law produces a more just result, both in the present case and in the generality of cases. And there is also a distinction between an overt appeal to emotion and the setting forth of facts that may engage the judge's emotions uninvited. You may safely work into your statement of facts that your client is an elderly widow seeking to retain her lifelong home, but don't make it an overt, passionate attempt to play upon the judicial heartstring. It can have a nasty backlash. Excellent. 18. Assume a posture of respectful intellectual equality with the bench. The Solicitor General of the United States Corporation, the most frequent and often the most skilled advocate before the Supreme Court of the United States, is sometimes called the 10th Justice. Every advocate has the opportunity to deserve this description, to be so helpful to the court as to be a colleague of sorts, albeit a junior one. And that is the sort of relationship with the court, a relationship of respectful intellectual equality, that counsel should try to establish. Some appellate judges refer to oral argument as the beginning of the court's conference, an initial deliberative session in which counsel participate. Some pretty good stuff here. Intellectual equality requires you to know your stuff, to stand your ground, and to do so with equanimity. When you write your brief or stand up to speak, have clearly in mind this relationship that you wish to establish. It is not the relationship of a teacher to student. And if the judges get the impression that it is your view of things, that you will have antagonized them. Nor is it the relationship of supplicant to benefactor. You are not there to cajole a favor out of judges, but to help them understand what justice demands on the basis of your intimate knowledge of the facts and law. You are not there to cajole a favor out of judges, but to help them understand what justice demands on the basis of your intimate knowledge of the facts and law. Perhaps the best image of the relationship you should be striving to establish is that of an experienced junior partner in your firm, explaining to a case to a highly intelligent senior partner. Wow, excellent. Respect for the court is more effectively displayed by the nature of your argument, by avoiding repetition, for example, and by refraining from belaboring the obvious. Then by such a lawyerly obs oh geez obsequiousness as if your honor please, or with all due respect. Okay, here we go. Obsequiousness. Obsequious. Such lawyerly obsequiousness as if your honor please. So obsequiousness. Anyone know what this word means? Because we're about to check with Black's Law. Because in Black's Law, it's hard enough to say the word. Now we have to look it up. Obsequious. All right, let's see here. Oh, somewhere around here. Okay, hostage in wartime. All right, let's go back to this word here again. Obsequi. Okay, come on, get back here. All right, we gotta wait for it to catch up the scroll here. This is a scanned document. It takes forever to interact with us here. Come on. All right, maybe I could just come back to it like this, and just a moment here. Okay, here we go. Obsec. I just missed it, didn't I? What the heck? That was down here. Huh. I didn't see it. All right. Well, I guess just a standard word. If that's the case, we can just look up in a regular dictionary and find out what it means. Obsequious. Obedient or attentive to an excessive or servile degree. From the late 15th century. To follow, comply with, compliancy. So to be compliant. But an excessive or servile degree, like a servant or a slave. Oh, your honor. Okay, so we get that down. All right, no word left behind. Let's get back to the book. So, lawyerly obsequiousness as, if your honor, please, or with all due respect. Of course, if you're going to err on the point, it is probably better to be unduly differential than not differential enough. An advocate should be instructive without being condescending, respectful without being obsequious, and forceful without being obnoxious. So this is a good one. An advocate should be instructive without being condescending, respectful without being obsequious, and forceful without being obnoxious. Man, that's a pretty good from T.W. Wakeling. Let's read this one more time. An advocate should be instructive without being condescending, respectful without being obsequious, and forceful without being obnoxious. So great words of wisdom here. And we get right to it. 19, restrain your emotions and don't accuse. Don't show indignation at the shoddy treatment your client has received, or at the feeble and misleading argument Are we back? Check, check. Have we returned? All right, I think we're back. Are we all still there? All right, I believe we're back. Greetings and welcome back, everybody. All right, I don't know what happened there, but we're back. So, where we left off was section 19, restrain your emotions and don't accuse. So, we won't make any accusations here. Let's get right back down to it. And let me just make sure everything else is happening here. Give me a moment to get everything moving again here. Come on. And there it is. Indeed, now I get it. All right, we're all back. 100%. Don't show indignation at the shoddy treatment your client has received or at the feeble and misleading arguments raised by your opposing counsel. Describing that treatment and dissecting those arguments calmly and dispassionately will affect the court quite as much, and it won't introduce into the proceeding the antagonism that judges heartily dislike, nor will it impair your image as a reliably rational and even-tempered counselor. Ideally, you should evoke rather than display indignation. So you want to be reliably rational and even-tempered, yet you want to be able to evoke rather than display indignation. Here we go. Cultivate a tone of civility, showing that you are not blinded by passion. Don't accuse opposing counsel of chicanery or bad faith, even if there is some evidence of it. Your poker-faced public presumption must always be that an adversary has misspoken or has inadvertently erred, not that the adversary had deliberately tried to mislead the court. Yeah, it's imperative. As an astute observer on the trial bench puts it, an attack on opposing counsel undercuts the persuasive force of any legal argument. The practice is uncalled for, unpleasant, and ineffective. Although some may say it is somewhat satisfying, though, depending on which side of it you're on. But I digress. This advice applies especially against casting. Come on, there we go. All right, this practice is uncalled for, unpleasant, and ineffective. This advice applies especially against casting, in pejorative terms, something that opposing counsel was fully entitled to do. Nor should you accuse a lower court of willful distortion, even if that is obvious. A straightforward recital of the facts will arouse whatever animosity the appellate court is capable of entertaining, without detracting from the appearance of calm and equanimity, if that you want to project. If the court concludes that the law is against you, it will not award your client the victory just to embarrass a rogue trial judge. All right. So section 20, control the semantic playing field. All right. Labels are important. That's why people use euphemisms and why names are periodically changed. And that's why you should think through the terminology of your case. Use names and words that favor your side of the argument. Consider American Airlines. Some lawyers who have represented the company call their client AA in briefs, perhaps as a space saver. That passes up an opportunity for subliminal reinforcement. If American Airlines is your client, you have the opportunity to call your client American, knowing that every judge sitting on your case, unless you are in some international tribunal, will be an American. Of course, if you're opposed to American Airlines, you will call your adversary the company, the corporation, or perhaps even the carrier, never American. If you can get your adversaries to use your terminology, so much the better. Sometimes it's not a proper name at issue, but an event. Some years ago, Warren Christopher represented Union Oil in connection with some major spills at offshore oil platforms in the Santa Barbara Channel. From the beginning, Christopher persistently referred to this potential environmental disaster as the incident. And soon both the judge and even the plaintiff's lawyers adopted this abstract word uniformly. Anything more concrete, from Union Oil's point of view, would have conjured up prejudicial images. Interesting there. So the terminology that you use to define your case, your argument, should be something that subliminally reinforces any kind of benefit that your side would have in the minds of judges, juries, and if you can get the opposing side to adopt your terminology, all the better. Interesting there, too. All right, let's proceed. Judge James L. Robertson of Mississippi has recounted a splendid example of his use of disputational semantics. I love this. Disputational semantics when he was in practice. He was challenging some unduly restrictive outside speaker regulations on Ole Miss College campus. During the proceedings, he and his partners kept referring to the lawsuit as the speaker ban case. Soon everyone was doing it. That done, the outcome of the case seems to have been foreordained. Would you be inclined to vote for or against a speaker ban? Pretty good one. Of course, semantic astuteness must not degenerate into sharp practice. In a high-profile medical malpractice action some years ago, a hospital executive named Lyman Sarnosky, the last name is fictional, was accused of falsifying medical records. The plaintiff's lawyers repeatedly referred to him before the jury as Lyman. Oh gosh. Emphasizing the first syllable of his name to suggest undoubtedly that lying was part of his nature. It was not long before the judge ordered them to refer to the man as Mr. Sarnosky and levied a $5,000 sanction on the lawyers. Even if the judge had not taken offense, the jurors probably would have. Oh my gosh. Now that's a good one to end on for tonight. And we're going to continue next time on section 21. Close powerfully and say explicitly what you think the court should do. So this should leave us ready for the next one with a little bit of humor here from this last little anecdote here with Mr. Lyman. What a great name. On that note, let's see here, semantics, yes. Indicative forces and semantics gets into a whole nother branch of science almost, which would also be connected with other aspects of communication. Semiotics, semantics, ontology, and all of these are combined to be able to express law in a way that we can all agree on over the ages and be able to have a consistent way of interpreting the best ways that to date people have been able to actually construct the rule of law into the written word. So to bring natural law into the written law is an accomplishment that is almost transcended in a way. So it's worth preserving when it's done perfectly, which means all parts are there. It's not incomplete. And whether it's perfect or not, our style of American jurisprudence has gotten as close as we can to it thus far from what we have record of in civilization. So, salute to you all for being here to take this journey of how to best exercise our power when we're dealing with making our cases and being in front of judges and understanding the way that they perceive some of these cases too. And they are humans as well. To some extent, we need to be able to acknowledge their challenges and their day to day requirements of accomplishment. So, on that, I'd like to thank you all once again for coming. I salute you all for being here and spending the time to follow me on this journey of making your case. And I hope to see you all on the next one. Make sure you subscribe and hit the bell notification so that you're able to get the notifications, hopefully, of the upcoming streams. Notifications have been thin, so try to make sure that you have that bell turned on and you keep alert on the channel. I'll try to put out community posts too to keep you all alert. On that note, I salute you all, and I'll see you on the next one. Peace out.